Most attorney-client relationships end when the case ends. But what if your lawyer isn't getting the job done? What if they're dragging their feet or charging fees that don't make sense? What if you just don't like them? The good news is you always have the right to fire your attorney, assuming your attorney is a privately retained attorney and not a court-appointed attorney. But before you fire off an angry email, there are a few things to keep in mind. First, timing. If you fire your attorney right before a hearing or trial, you might need to request a delay, what's called a motion for continuance. But here's the catch. The judge doesn't have to approve it. If they say no, you could end up representing yourself, at least temporarily. Then there's money. Your attorney is entitled to payment for the work they've already done, and they may not release your case file until the bill is settled. If your attorney is working on a contingency fee basis, meaning they only get paid if you win, you typically won't owe them anything up front, but they may still place a lien on your case to recover fees for work they've already done. This means your new attorney could have to negotiate how those fees are handled before taking over. So when is it time to cut ties? Not every bad experience means you should fire your lawyer, but there are some clear red flags. First, they don't seem to know what they're doing. Every lawyer has an ethical obligation to provide high-quality work. This doesn't mean your lawyer can guarantee that you'll win your case, but it does mean your lawyer should have the competence to represent you effectively and professionally. Second, they ignore your instructions. Your lawyer handles strategy, but big decisions like whether to settle, those are up to you. If they're pushing you into something you don't want, that's a serious issue. Third, they're dragging their feet. The legal process does not move fast, but if your lawyer is missing deadlines or delaying things without good reason, that's on them. Fourth, they won't communicate. You shouldn't have to chase your lawyer down for updates. If they ignore calls and emails or won't explain what's happening, it might be time to move on. Fifth, their fees don't add up. You have the right to know exactly what you're being charged for. If your lawyer won't explain their fees or they seem way too high, it's a red flag. And finally, they break your trust. If your lawyer shares confidential information or mishandles your money, that's not just reason to fire them. It could be an ethics violation. Before firing your lawyer, it's in your interest to have a civil conversation. Sometimes just bringing up the issue gets things back on track. If that doesn't work, your state bar association may offer free mediation services to help resolve disputes. If you're definitely done, you need to send a formal termination letter. It's best to keep it simple. Put it in writing and send it by certified mail so there's proof of receipt. Be direct. State that you're ending the relationship immediately. Be firm but polite. Burning bridges can make it harder to find a new lawyer. Lastly, request a copy of your case file so your new lawyer can pick up where they left off. If you need help, we've got a sample termination letter and a fill-in-the-blank template. Just click the link below.